West Virginia transgender athlete defeated girls in track events over 700 times, new legal filing says. None of this is justifiable, the motion states. A new court filing in a lawsuit against the Biden administration for its overhaul of Title X claims that a transgender track and field athlete at a West Virginia middle school displaced girls in competition over 700 times in 3 seasons. On Thursday, the Alliance Defending Freedom, ADF, a non-profit civil rights firm, filed a motion asking the Sixth Court of Appeals to stop the Biden administration's new Title X rules from going into effect on August 1st and to allow state laws that ban transgender athletes from playing on girls' sports teams to stay in effect. The rules issued by Secretary of Education Miguel Cardona last month says that sex discrimination includes discrimination based on gender, identity, as well as sexual orientation. The administration has claimed that the change wouldn't affect the sport, but attorneys for ADF say that that's true. The Biden administration's radical redefinition of sex will upend the equal opportunities that women and girls have enjoyed for 50 years under the Title X and will threaten their safety and privacy at every level, ADF Senior Counsel Rachel said in a statement. While the administration claims this change won't affect sport, it has already made its position clear that men who identify as women should compete in women's sports under Title X. Rowe said. The Biden administration has supported the efforts of one student who identifies as transgender to compete against ADF's client and other girls in women's sports in West Virginia, ADF says. After a federal court ruled against ADFs and allowed the student to compete on other girls' team, that athlete finished ahead of girls more than 700 times in cross-country and track and field events, ADF claims. Our client has also lost her right to use the women's locker room free from harassment and without a male present. This egregious example is just one of the many ongoing difficulties girls are facing with this legal rewrite of federal law and vast executive authority overreach, Rurals said. ADF's motion was filed as part of an ongoing lawsuit launched by Tennessee Attorney General Jonathan Scarrett and over 20 other states against the administration's new rules. 50 years ago, Congress revolutionized our educational system. In 1997, nearly 34% of working women lacked high school diplomas. In 2016, it was 6%. In 1972, 7% of high school varsity athletes were women. In 2018, it was 43%. The change occurred because the people's representatives balanced various interests and produced legislation centered on 37 words in Title X of Education Amendments of 1972. No person shall be excluded from denied benefits or subjected to discrimination in educational programs on the basis of sex, ADF's motion state. A different sort of revolution took place a few weeks ago. On April 29%, an elected Department of Education officials published Title X rules that added the concept of gender identity, an individual sense of their agenda. The new rules sometimes even prioritize the subject concept over someone's objective sex, requiring schools to allow some men to use women's restrooms, to change in women's locker rooms, to shower in women's showers, and to compete in women's sports, the motion states. The result is that Title X primary beneficiaries are denied the privacy, dignity, equality, and fairness needed to benefit from our educational system, it says. None of this is justifiable or justifiable, it states. The Department of Education previously told Fox News in a statement that it does not comment on the pending litigation. The department crafted the final Title X regulations following a rigorous process to give complete effect to the Title X statutory guarantee that no person experiences sex discrimination in a federal funded education, the statement reads.